Welcome to the third panel. Welcome to the third panel of the U.S. Commission on Civil Rights on bail reform. Our speakers today are extraordinary, and we're going to proceed to, let me introduce them to you. Our first speaker in the order that they're going to talk is Megan Stevenson, Dr. Stevenson, Assistant Professor of Law at the University of Virginia. Our second panelist is Erika Maye, Deputy Senior Campaigns Director for Criminal Justice, Color of Change. Our third panelist is Elijah Gwynn, co-founder and CTO of Uptrust. Our fourth panelist is Michelle Esquenazi, President, National Association of Bail Agents. And our fifth panelist is the Honorable Douglas Herndon, Associate Justice of the Supreme Court of Nevada. I'm going to remind everyone that we've got 5 minutes each for the presentations, and you will see a timer in front of you. So we would start, please, with Dr. Stevenson first.
Thank you so much. Each year, hundreds of thousands or even millions of people are locked up solely because they're believed to pose a public safety risk. These people are legally presumed innocent. They have not been convicted of a crime that would justify their incarceration as punishment. The Supreme Court authorizes pretrial detention on the basis of, quote, dangerousness only under very limited conditions, when the government's interest in preventing crime outweighs the individual's interest in liberty. In other words, the legal standard for pretrial preventive detention is a cost-benefit test. It must, at a minimum, avert more harm than it generates. So how do you weigh the relative costs of crime victimization and incarceration? Traditionally, in order to develop measures of goods that are not bought and sold on markets, things like crime or pollution, economists use a technique called contingent valuation. A co-author and I developed a form of contingent valuation that allows us to estimate the relative costs of crime victimization and incarceration. We ask respondents questions such as, if you had to choose between spending a month in jail or being the victim of a robbery, which would you choose? In short, we find that people are incredibly averse to incarceration. Most of our respondents reported that a single day in jail imposes harms greater than burglary. 3 days in jail impose harms greater than robbery. A month in jail imposes harms greater than a serious assault. And these responses are not just uninformed speculation. Even those who have personal experience with incarceration and or crime victimization report that jail is incredibly harmful, and even short stays can impose harms as grave as serious crime. Now, back to our cost-benefit analysis. Once again, a legal precondition for pretrial preventive detention. If jail is so harmful, then a person must pose an extraordinarily high risk of committing serious crime in order to justify pretrial detention. In order for pretrial detention to avert more harm than it creates, you would have to avert crimes as grave as burglary in order to justify caging someone for a single day, avert crimes as grave as robbery in order to justify caging them for 3 days, avert crimes as grave as serious assault in order to justify caging them for a month. But here's the catch. It's hard to identify in advance who's going to commit serious crime in the future. Even our best predictive tools are nowhere near accurate enough to identify individuals who pose a high enough risk of serious crime to justify pretrial detention on the basis of dangerousness. In one commonly used risk assessment tool, only 2.5% of those in the highest risk category are expected to commit a violent crime within 30 days. At that risk level, the harms of incarceration are probably 40 times greater than the benefits of averted crime. Under the legal theories to justify pretrial detention, a cost-benefit rationale, pretrial detention on the basis of crime risk should be extraordinarily uncommon. The harms of incarceration are very high, and it's difficult to predict future activity with confidence. But pretrial preventive detention is not uncommon. Each year, hundreds of thousands or even millions of people are being placed in cages with no clear rational or legal basis. Even though these detentions are justified or purportedly justified Because of the crime risk people pose, they generate vastly more harms in terms of lost liberty than they avert in terms of prevented crime, and therefore run afoul of constitutional limits on pretrial punishment and excessive deprivations of liberty. Now, what enables courts and society to accept this condition? Likely it's because people detained are disproportionately Black, brown, and poor people who have been alleged to have committed a crime. Such allegations, in conjunction with invidious stereotypes about race, class, and criminality, have numbed our society and allowed them to shrug off the harms experienced by a caged person when weighed against the slim chance that detention could avert a serious crime. The dialogue in bail reform has largely been concerned with mechanics. Should we get rid of cash bail? Should we replace it with risk assessments? I'd like to argue that these debates are secondary. The scale of pretrial detention is simply massive, and the harms it generates are unjustified. Eliminating monetary bail does not necessarily wind down pretrial detention rates. Adopting risk assessment does not necessarily wind down pretrial detention rates. To make detention truly a carefully limited exception, we need firm laws that make the bar for caging appropriately high and accountability measures to ensure that the law is being properly implemented. Gathering the political will to achieve change on the necessary scale requires shifting our culture and beliefs. Right now, change on the scale I'm advocating might look politically unfeasible. At one point, ending segregation was politically unfeasible. The United States Commission on Civil Rights was a leader then. It must be a leader again now. Thank you.
Thank you. Thank you, Dr. Stevenson. Very eloquent. Did someone say something? I'm sorry. Okay. Thank you, Dr. Stevenson. Next, we'll hear from Dr. Maye, from Ms. Maye. Please proceed.
Thank you. Good afternoon, commissioners. Thank you for having me today. I am Erika Maye, Deputy Senior Director for Criminal Justice and Democracy Campaigns at Color of Change. Color of Change is the nation's largest racial justice organization, representing more than 7 million members. We have been at the forefront of national efforts to end money bail, releasing a first-of-its-kind report exposing the exploitative commercial bail industry, getting Google and Facebook to ban bail bonds ads, working with reform prosecutors to end pretrial detention, and helping launch national campaigns such as the National Bailout, which has bailed out hundreds of Black mamas and caregivers over the last 5 years. Growing momentum for ending money bail spans the political spectrum in all levels and branches of government. I know in the last panel you all heard that just this week, the Illinois governor signed a historic criminal justice reform bill ending money bail statewide. The federal government also has a critical role to play in ending money bail. Money bail creates a system of wealth-based detention that criminalizes poverty, worsens racial bias in the criminal justice system, and extracts wealth from poor and Black communities. Money bail also exacerbates overcharging and coerces guilty pleas, depriving people of rights to defend their innocence. Across the country, Black and brown people are at least 10 to 25% more likely than white people to be detained pre-trial or to have to pay money bail. Black men receive on average 35% higher bail amounts than white men, and it's no surprise that most people in jail unable to pay money bail are from the poorest third of society, and that Black people are particularly impacted. 3 days in jail leaves people charged less likely to appear in court and more likely to be rearrested. This is because of the stress incarceration places on jobs, housing, custody, and loss of critical community connections. For 28-year-old Sandra Bland, who died in a Waller County, Texas jail, unaffordable bail played a key role in her death. She was just one of hundreds of people who had not been convicted that year who lost their lives in jails. This is a community, not an individual problem. Pretrial detention bleeds Black communities and their resources and perpetuates a cycle of poverty and jail time. Nearly half of all Black women in the United States have a family member behind bars, and women are primarily responsible for court-related costs associated with pretrial detention. That's money taken from families, children, and communities. The billion-dollar commercial bail industry profits off of Black communities, taking advantage of the urgency of detention to bind people and their loved ones to predatory contracts that can mean debt and payments that last far longer than any court proceedings and continue to burden families regardless of drop charges or innocence. Common provisions require people and their families to sign away their privacy through invasive surveillance. This exploitative industry is a global anomaly. Insurance companies collect a cut of most commercial bail bonds. In recent years, momentum for bail reform has led global insurance giants to leave the shrinking pariah industry. And now Canada-based Fairfax Financial Holdings is by far the largest backer of bail, followed by an increasingly consolidated group of insurers. Those left in the industry continue to fight bail and pretrial reforms and reforms that reduce arrests, therefore reducing their pipeline of customers. They do this through millions in lobbying and political contributions and through associations like the American Bail Coalition and the National Association of Bail Agents. The industry also runs misleading, dehumanizing, and fear-mongering publicity campaigns to block or roll back reforms. Despite the industry's efforts, there is bipartisan agreement that money and profiteering should not be the gatekeeper of pretrial detention and release. The federal government should investigate the unconscionable contracts of the for-profit bail industry that systematically violate consumers' rights and exercise its enforcement and regulatory authority to protect vulnerable people. Ending money bail must replace it with policies that honor the presumption of innocence and address the root causes for why people may not appear in court for trials and pretrial hearings in the first place. We must not replace one punitive and racially discriminatory system with another one filled with fees, new profiteers, and incarceration. The federal government can advance sound systemic reforms through issuing guidance to states and overhauling the DOJ's grant-making strategy, conditioning grants and increasing funding to jurisdictions, ending money bail, and replacing it with tools that don't further perpetuate racial bias in the criminal justice system. The federal government can also support needed reform by working with Congress to pass the No Money Bail Act. My written testimony expands on these areas. Thank you so much for your time today.
Thank you. Thank you. Next, we will hear from Mr. Gwynn. Please proceed.
Thank you, and good afternoon, commissioners and commission staff. My name is Elijah Gwynn. I am the co-founder and chief technology officer of Uptrust. Uptrust is a public benefit corporation which builds software tools to help individuals navigating the criminal legal system, attend mandatory appointments, and avoid technical violations. We achieve this goal by connecting defendants to their public defender on our two-way messaging platform and by sending automated reminders with important information about their court appointments. As of this month, we have messaged over 200,000 individuals and have messaged them about over 1 million court dates. We've improved attendance by around 50% for the individuals we've reached. My business partner and I started Uptrust because we thought that cash bail was not the right way to solve the problem of court attendance.
Okay.
Everywhere we went and everyone we spoke with would keep talking about how bail was often set based on how the often low-income defendants were at high risk of flight. And this seemed kind of crazy to us because around 80% of the people going through the criminal legal system are represented by public defenders, making them de facto at or below the poverty line. This is a population of people that don't have the resources to flee, even if they wanted to. And most prosecutors and judges we saw were underweighting individuals' community ties when they were making their decisions. Almost nobody was questioning the underlying assumptions about whether using bail as a financial incentive was actually the right strategy for getting people to come to court. Also, these ad hoc decisions to detain an individual pretrial were not without costs, as some of my other fellow panelists have mentioned. Jailing individuals pretrial costs taxpayers an estimated $10 billion per year. And this financial cost excludes the complete upheaval of defendants' lives and the consequences downstream ranging from lost jobs, eviction, family separation, etc. This latter cost is underdocumented, but considering the countless lost jobs we see and amount of increased trauma, I estimate is also in the billions of dollars. So our response at Uptrust was to build our business and our products around understanding and addressing the underlying reasons why so many defendants miss court. We discovered that, contrary to popular belief, the vast majority of indigent defendants do wish to comply with the court orders during the pretrial period. However, a combination of factors, including psychological, social, and organizational challenges, were the biggest issues for following through with this intention. Our strategy has been to amplify the ability of client representation, their public defenders, to help with these kinds of issues. As I mentioned before, This approach has been very successful. Indeed, the #1 response to our messages is thank you. This clearly demonstrates that financial requirements are not necessary to ensure attendance and that there exist alternatives to the use of cash bail in the millions of judicial cases involving low-income defendants. Much has been written about the problems and sometimes horrors of the money bail system, and many individuals are here to echo those same sentiments. However, it's less clear what the solution is. The most common bail reform measure we hear about at Uptrust are risk assessments, and there's nothing wrong per se with the idea of an assessment tool, but the current offerings in our estimation are frequently too narrow in scope and too focused on formalizing and automating the already structurally racist status quo. If a defendant misses court because they never received the mailed reminder, or because they were rearrested because their neighborhood is already over-policed, just as they are more likely to have an unaffordable bail set, they are more likely to be considered risky by a pretrial risk assessment tool. Furthermore, as we demonstrated at Uptrust, these factors aren't static the way many risk assessment tools treat them. We found that many defendants have immediately addressable needs that have a big impact on their ability to attend court. For example, in Spokane, Washington, a place where we work, the court provides childcare on site for defendants to use. And besides childcare, we've seen other low-cost interventions address the needs of low-income defendants, such as rides to court for those without access to transportation. In Hennepin County, we've seen that. Or connection to Lifeline, an existing federal program that connects people to, that provides low-income individuals with free cell phones. These address the underlying issues of poverty that drive the lack of appearance and have falsely made bail appear to be the solution. All of these interventions are much cheaper than the billions spent incarcerating the exact same people who can't afford bail or who are deemed risky. We've seen community bail funds, an engaged public defender, or a software intervention like Uptrust can dramatically increase the likelihood of helping someone attend court, which is the key provision that bail is meant to assist. It's my hope that we invest further in community-oriented approaches, which are cheaper, more effective, and less destructive than the use of money bail going forward. Thank you.
Thank you. Thank you, Mr. Gwynn. Ms. Esquenazi, we look to you now for your testimony.
Thank you, and good afternoon, commissioners. I'm honored to speak to you today in support of secured bail. My testimony has been submitted. My name is Michelle Esquenazi. I am a proud bail agent. I grew up in Brooklyn, New York, a single mother of 4, and a domestic violence survivor that escaped with 2 children and 1 in utero by the age of 25. My ability to bring you perspective comes from real life experience as a crime victim and a Cuban-American woman. Our profession comes in every color, orientation, and ethnicity. We are the epitome of mom and pop shop America. We are owned and operated by upwards of 65% minorities and women. Bail does not judge anyone, certainly not the accused, by skin color. As I mentioned, we come in every color of the rainbow. Our successful role in the criminal justice system throughout the nation should never be ostracized or ridiculed. The truth of every truth lies somewhere in middle path. So I encourage all of you today to journey with me towards the greater good of humankind without stereotypes. Clearly, we should all seek to judge one another by the content of our character, and the fiber of the men and women that represent the bail industry is virtuous. I take exception to the many that crucify who we are and what we do by listening to one side. I encourage you to meet with us, talk with us, get to know us. We are the bluest of blue shirt America. Human rights justifiably belong to every person, and we are indeed a group of humans with children and families. We simply ask for a seat at your table. The notion of bail reform and civil rights have long been argued together, and often become mixed into the same branded talking points that have been published in a cut, copy, paste way for as long as I can remember. Offender rights are important, and bail should never be designed to be punitive. We believe that. We believe that first-time offenders and persons accused of certain crimes should be subject to rehabilitation and a hand up. We do not believe in bail setting practices that serve to impugn minorities. We do not want to see anyone remain incarcerated that should have a pathway to liberty. We believe in a hybrid system of bail in which we remain a viable part of the solution. Habitual offenders thrive by the circle of love indemnity that comes with the secured bail liberty. No matter what side of the issue or aisle one might be on, everyone does better in life with the love and support of family and loved ones. This unique relationship between bail agent and family not only produces the accused in court, but also serves to ensure the victim their day in court. The other side of this issue that is often overlooked is what happens to one's civil rights when denied the right to bail. In the state of New Jersey, no one has the right to bail. They actually amended their state constitution. Ed Fortune, an honorably discharged African-American United States Marine, a peaceful political pothead by his own admission, was, according to him, New Jersey's first political prisoner. Held in jail 447 days, Ed lost everything, including the right to see his severely disabled child, who depended on Dad for daily care. I offered the state of New Jersey a $2 million bond to procure his release. They would not take it because they could not take it. In New Jersey, you are either released on pretrial diversion or you are held through trial. There is no middle path. Secured bail is that path. The New Jersey weed man, as he is referred to, was charged with witness tampering after a long, tumultuous relationship with his local police department. Ed was judged by an algorithm that gave him a bad score. This practice has been criticized by the ACLU. The champions of civil rights throughout our history as a nation would have clearly disagreed with this extreme. To this day, there are countless humans incarcerated in New Jersey that should be submitted to secured bail liberty. This practice is a clear violation of the civil rights of any accused. In closing, I implore each and every one of you today to put down the fancy graphs and one-sided statistics and continue a dialogue with us as stakeholders. We are not the enemy simply because we earn a living at what we do. Most here today are paid to work. There is no shame in that theory. Our role in the criminal justice system is small, yet valuable, and we are proud of the work that we do on the front lines. There is always room for reform in every arena, but never at the expense of trampling on the civil rights of anyone. The Eighth Amendment gives all of us and our children the right to bail. It is incumbent upon us to define this issue for all time together as one group of humans that deeply care about the civil and human rights of all people.
Thank you, Ms. Esquenazi. Justice Herndon, we'll hear from you now, please.
Thank you, Commissioner Cantu. And just a real quick shout out and thank you to Marique for getting me involved in this and helping my technology challenge self to arrange to join you all today. Everybody has kind of hit on a variety of things that make the job of the judge so difficult when it comes to pretrial detention decisions. I'm a little older than the rest of you, I think. So I've been involved in the criminal justice system for close to 32 years now. First as a prosecutor for about 14 years, then as a district court judge for a little over 15 years, and now as a Supreme Court justice. I think that the vast majority of reasonable people would agree with two things. Many people that are arrested and charged with crimes pose no danger, particularly a violent crime, and no flight risk, and deserve to be released, sometimes with some type of condition, other times just on an own recognizance release. There are people, however, who do pose a danger, particularly to commit violent crime, and they pose a danger to public safety. And those are the people you seek to make sure they either stay in custody or they're going to have bail settings that are higher if you can't come up with some other least restrictive means of releasing them. How you identify those two classes of people, and for that matter, all of the people in between that, maybe they're going to commit a nuisance crime or something, but probably shouldn't be held pretrial detention. But how you identify these people and how you fashion resolutions to benefit them is where we fall in the criminal justice system, with so many difficulties for judges, whether, in my mind, it's a bail system or not. I know a lot of people worry about non-bail systems, like Ms. Esquenazi was just stating, that judges default to detention just because of a fear of what's going to happen if they release somebody and there's no conditions involved or there's no bail, whatever it may be. And then in a bail system, obviously, you worry that you're setting bail amounts for people that couldn't make $100, much less $1,000 or $10,000 or anything else. So these are very, very difficult decisions. Back when I first started 30 years ago, even to me back then, it was rather shocking that as a prosecutor, defense attorneys would argue to a judge about their client's contacts to a community, their client's lack of prior criminal history. And the questions the judges usually asked were, what did the person do? Not what are they alleged to have done? What are they charged with and what did they do? The default back then seemed to be more towards punishment, right? As if the person was already guilty and we need to keep them in custody, versus presumption of innocence and let's talk about default to release. Thankfully, I think that that's somewhat changed over 30 years. I know in Nevada over the last 5 to 7 years, we've had several things happen that have been a great awakening. A lot of it comes from pressure from the criminal defense bar, lawsuits that are filed over overcrowding in detention facilities, as well as internal pressure within the court system to get judges to understand the role that they play in a pretrial decision versus a sentencing decision. And then we had a commission that was established several years ago that we produced a pretrial risk assessment tool, which was designed to give judges a higher comfort level when they were making release decisions about what they could do to fashion ways to make sure people reappear for court. We had a Supreme Court decision come down a couple of years ago, which was massive in terms of bail decisions, because prior to that time, defense attorneys didn't really challenge bail decisions at the appellate court level because it delayed their case. And if their client took a negotiation, it was going to be mooted by the fact that the case had ended. Fortunately, they pursued a case, got a Supreme Court decision directing the trial courts as to how to deal with bail decisions in a more express fashion, which impacted things greatly. And probably the one thing that has really impacted it has been COVID-19. People don't realize the benefit that's come from the COVID-19 outbreak and what it's forced judges to do to be more aware of releasing people, taking chances on low-risk individuals, and fashioning ways to release them. It's never a math problem. There's always going to be discretion that judges have to issue these release decisions. Sometimes I fear that we try and law things to death and create more and more laws, but when it involves a discretionary act by the judge, I think we're better served oftentimes by more education for judges about the research and what it tells us about pretrial incarceration, the low risk that offenders have for reoffending while out, and or flight risk. Things like what Mr. Gwynn is involved with are terrific. That's what we need at the state and local level that we don't have, which is resources available to help ensure people come back to court and stay in contact, because communication solves everything when you're talking about the risk of not coming back to court. So thank you very much.
Thank you, Judge Herndon. At this point, I will accept questions from the commissioners. I'm sorry, did I miss someone? Sorry, I may be getting an echo. I'm going to accept questions from the commissioners. If I can call on Commissioner Yaki first.
Yeah, thank you very much. Mr. Gwynn, I just wanted to focus a little bit more on your particular program. Tell me a little bit more about what it is you think is the right way to sort of prevent the pre-incarceration of people in this country based on their color.
Yeah, absolutely. I think that a lot of this comes down to trying to reframe the question of what it means to not show up to court in terms of like less away from the risks per se and more in terms of the things that they need. I think that when you take a look at the communities that are most affected, you see a lot of these factors of poverty come up that, you know, really underpin, like a lot of us have given lots of examples of, you know, losing job and housing and your family. And a lot of these things are rooted in poverty. And so taking a close look at the kind of executive dysfunction that can arise when you don't have the resources, and taking a look at those communities, which are, you know, disproportionately communities of color, to wit, you take a look at some of those things, I think you find that those needs are addressable. And if you can start picking them apart, you can start identifying those ones where you can make the biggest difference. And at Uptrust, that's what we do. We try to look at the various needs that people have sort of on a whole scale. And we find that we can take very, very cost-effective means to address those issues.
Thank you. Madam Chair. You're on mute, Madam Chair.
I'm sorry, you catch me at this so well, and I appreciate you. Commissioner Kladney, do you have questions?
Thank you, Commissioner Cantu. Justice Herndon, thank you for coming today. I know that the court recently issued a decision which I think greatly narrowed and explained the bail system in Nevada. The decision required defendants to have counsel, to have a speedy hearing, and a lot of elements to be addressed and open to the defendants. I was wondering though, as I was rooting around the internet, I found the 8th Judicial District bail schedule. And I was wondering how those two mesh, because it seems it calls for $1,000 bail on misdemeanors, $2,000 on $3,000 on battery, DUI is $3,000, and if you go to a certain kind of crime, it doubles the amount, the standard amount they call it. And you were a judge in the 8th JD, so I was wondering how the judges and the courts and the jail are supposed to put all this together.
So a couple of things. Very good question, Mr. Kladney. First off, the 8th JD doesn't come up with that bail schedule. It's kind of foisted upon us. The bail schedules, standard bail schedules, are developed by the justice courts, the probable cause courts, in conjunction with the sheriff. Because as you can imagine, the vast majority of people, their appearances are not through an indictment process, at least not in Nevada. They're through the justice process where they get charged and a criminal complaint is filed. So the district court deals with bail 25% of the time compared to the justice courts. So the standard bail setting was created down there so that when people are arrested, there's an automatic bail setting for them before they get in front of a judge, whether it's that day or the next day, in case they have that bail and can make that bail. Now, that being said, when a case comes to district court at the trial court level, which are all felony or gross misdemeanor crimes, the way I have always viewed it and the way I told my judges to view it when I was the chief judge was blank slate, right? I mean, it doesn't matter what the justice court did. You need to individually address this on your own and decide, particularly now that it's been through the probable cause court. Maybe you have a little more information than they had down there about the defendant, about the allegations, about the defendant's community ties, his financial ability to pay, whatever it may be. So you need to independently revisit that separate from a standard bail schedule. Personally, I can tell you that I know why we have a standard bail schedule. I get the wisdom of that, but monetizing another human being, just like trying to figure out how to sentence somebody, to how many months in prison they're going to do is a very, very difficult process. And I don't know that standard bail per se really is appropriate, quite honestly, because one person should be out right away and another person shouldn't be out at all. And maybe those standard bail schedules don't really reflect that. But I guess you need to have something right away when somebody gets arrested.
Well, one of my big things is, especially with misdemeanors, that's where most, if it's a criminal defendant, that's where most people come in contact with the system.
Sure.
And it seems to me that a bail schedule where somebody has to get out, I mean, and never is going to rise above the justice court or the municipal court, is stuck with this bail schedule, absent getting in front of the judge, which is sometimes very difficult, especially on weekends,
right.
Things like that. So I was wondering, do the sheriffs have discretion in letting people out ROR or that kind of fashion? I mean, is there some way to fashion a more equitable way to treat the lower level crime?
So yes, we have a number of things. First off, we've had a standing depopulation order for forever that allows the sheriff to just release people out of the detention center with overcrowding issues. And that usually applies to misdemeanors. But more importantly, as part of the overhaul that's been taking place for several years, even in line with the Valdez-Jimenez case, which you were referencing a moment ago that the Supreme Court handed down, there have been and I didn't deal with misdemeanors at the trial court level, but I know that those judges in the lower courts, the sheriff, all the justice partners had come up with some agreements to release people for most all misdemeanors absent battery, domestic violence, or DUI, I believe. Those had to get in front of a judge to decide whether bail was appropriate or a release condition. Standard bail could still be set. But on all the other misdemeanors, they were seeking to not set bail, to just automatically release them after they were arrested and processed, and then give them return court dates. I don't know if that was, quite honestly, and I apologize, kind of an exigency issue with overcrowding, or whether that was a moving forward issue. This seems to be the right thing to do. And whether it's still in place, I'm not sure.
Thank you.
Sure.
Thank you, Commissioner Cantu.
Thank you, Commissioner Adegbile. I give you the floor.
Commissioner Cantu, I want to make sure that you also get a chance if you have questions. So I yield to you in the first instance, and I'm happy to come behind you.
I do, in fact, thank you. And we can go over, it's our last panel, so we're not going to delay anyone behind us. So we can go over a few minutes. I was intrigued by Justice Herndon's suggestion that we should explore the possibility of judges being trained on the how to meet more of the interests of the broad group of stakeholders here. Are there other ideas for training other groups? I'm thinking prosecutors, defense counsel, staff involved in the court system. Do any of you have ideas on the other parts of the court system? And I'll start with the judge.
So look, I don't want you to think that I'm paving the way here for judicial education. That's been going on. We had training programs for our judges when we first instituted the pretrial risk assessment tool, trying to explain to them this process. And I've always been somebody that'll tell you up front that we got judges that shouldn't be judges, just like we have, you know, people working in construction that shouldn't be in that field. Any kind of profession you can imagine, there's people that probably aren't well suited to that. So kind of falls into you can lead a horse to water, but you can't make them drink. That doesn't mean you give up on educating people about the pitfalls of pretrial detention, however. What Ms. Stevenson was referring to, the very real and very clear empirical research on what happens if somebody's incarcerated for 1 day, 3 days, 5 days, a week, how it affects them moving out of that situation, having lost everything and or kind of beginning on the road to being more institutionalized within the criminal justice system, how bail affects impoverished communities, all of those things that I think probably are worth at least annual education for judges, if not more than that, not just on how to assess bail properly and how to utilize the tools properly, but how to understand what's going on with offenders and the risks that they pose in the community. One thing you learn very early on as an attorney in the criminal justice system, and you've probably all heard this before, about 10% of the people commit about 90% of the crime, which means you got 90% of the people that aren't really a risk to reoffend in any fashion. So you need to identify those in a pretrial detention setting as well, because we're not as concerned about those people moving forward. And I think the court system can always shoulder a risk that you don't come back when you're supposed to on this date or that date, right? You issue a bench warrant and somebody's going to get found. It really needs to start narrowing itself greatly to who is a risk for repetitive violent crime, preying on the community in that fashion, and target those people that need to be targeted for pretrial detention versus other folks.
Do you mind if I jump in here?
Yes, Dr. Stevenson.
So first, I know you didn't mean any harm, but it's Dr. Stevenson or Professor Stevenson. Second of all, I'm extraordinarily pessimistic that trainings are going to have a meaningful impact on pretrial detention practices. I've studied a variety of different reform initiatives that involve training and involve something actually even much more strong than training, very strongly worded bail reform laws that declare a presumption of release for all low and moderate risk individuals. This is Kentucky. This is the particular instance I'm talking about. And 80% of individuals in Kentucky are rated low or moderate risk. And the overall, what I find over and over again is that judges just don't really respond to discretionary reforms. They don't really respond to training. Maybe a little bit on the margins. I'm not saying, I'm not anti-training. But if you really want to see meaningful changes in our system, a couple of trainings are not going to do it. They're just not going to do it. The second thing that I wanted to add to our discussion previously, just in case anybody is uninformed about this matter, is that the types of bail schedules we were talking about previously are almost certainly unconstitutional. They've been struck down in a number of federal appeals courts already on the basis that they result in, they inadequately take ability to pay into account and therefore violate the Equal Protection Clause.
So do we have the right personnel? When I was thinking of training, I was thinking broadly in terms of having the right folk who know how to follow those strong laws that are in place. Is there someone who would like to offer an opinion on that? Ms. Esquenazi?
Thank you, Commissioner. I think that one of the consistent or the lack of a consistent point that's made in any of these conversations, all of which are so incredibly profound, is that there's a difference between a first-time or second-time offender, someone who gets arrested by happenstance or by virtue of color, and someone who is a recidivist. The fact of the matter is, and I have to disagree with you in a small way, Your Honor, and please excuse me, I don't mean to disrespect in any way, sir, is that the disparity is no longer 90-10. Because now you're talking about an addicted population during COVID. So it's yet to be studied, Commissioner. So basically what's happened is the addicted and then many that were let out of incarceration because of COVID-19 were no longer given their SSRIs. And the addicted are now incredibly much more addicted. So they're committing much, much more crime of moral turpitude and crime with human victim. So that's something that we always have to take into account, because the one thing about a criminal recidivist, a high risk offender, is that they do not choose their crime victim by virtue of political ideology. They do not pick their crime victim because someone has a green outfit or someone has a rainbow or orange outfit. That's not how it works. So there is a classification of humans that continue to commit crime. And what I'm trying to implore to many of the stakeholders here is just like possibly there's a way and a pathway for all of you to exist in the criminal justice system. So is the bail agent who's designed, who's at the inception of this great nation. Thank you, Commissioner.
Thank you. Another response to my question of the right people in the right roles? What about state legislators?
I think with regard to like the right people, are you talking about like the right people as stakeholders in the whole space?
I'm looking for gaps. I'm looking for folk who have not been invited to the table, who are stakeholders.
I know who.
We haven't mentioned Native Americans. We haven't mentioned families who have children with disabilities. I mean, are we missing someone that when we follow up with this, that we need to reach out to?
Fugitive recovery agents.
I think in my experience, the places where I would love to see a little bit more support are around those people who are able to kind of address the needs that a lot of the defendants exhibit. I think there's potential for people like social workers, people like, experts in how existing government services operate who can provide assistance to access more kinds of resources. When we take a look at breaking down the problem, it's isolating the biggest needs and finding the best way to address them, and then finding the next biggest set of needs to address, and kind of working our way down the line. In our experience, there's not so many people. There's the vast majority of people have those addressable needs, and finding more ways to, I think, shape policy around that reframing of the problem, I think is pretty promising.
Thank you. Thank you. Judge, you have your hand up. There we go. Still muted.
How about now? Can I ask a question of one of my other participants?
Yes.
All right, thank you. Hey, Elijah, it's Doug. Quick question. Does your, what you're doing, do you do it at the state and local level, or do you work with people at the federal level?
It's all state and local right now.
Okay. And here's why I asked that. I think the federal system, which generally doesn't have bail, right? They default to release or incarceration. They have a very robust pretrial services practice where they can help people when they're out on pretrial release prior to coming back to court, whether it's drug monitoring, communicating with people about court dates, et cetera. That is something that we generally don't have a lot of at the state and local level, at least particularly in Nevada. In fact, when you bring up, Commissioner Cantu, the idea of the legislature, politics are a huge role in this because of resources and budget. When we were looking at a lot of release decisions with our pretrial release commission, one of the things we had reached out to our county about, Clark County, was, hey, if we come up with a way of releasing a lot more people on pretrial detention and save you a lot of money, can that money be reinvested back into pretrial services to help coordinate and keep these people out of trouble and coming back to court? We got the big no thank you, right? We love it when you save us money, but we're not giving you any more money. That happens through politics. That happens through legislative change sometimes, ordering the counties to fund certain things. And I think if you had something like that in place, it would be just another tool to give judges more of a comfort level and hopefully making better release decisions, because they would know that somebody would be helped, not just their overworked public defender trying to call them the day before a hearing, right? But people helping them stay out of trouble, maintain drug counseling if that's something that's going to be beneficial to them, whatever it may be.
Very interesting. Commissioner, do you have follow-up questions? Adegbile?
Yes, I have just a couple. I was wondering if anybody on the panel wanted to speak to the best evidence that they're aware of that the disparities that we're seeing are on account of race, meaning that similarly situated people are being held under conditions that are more onerous when you look at the data in terms of how it's on race.
So I can address that. And I first want to say that even posing that question is extraordinarily difficult, because how do you define similarly situated? Is it similarly situated in terms of their criminal record? Well, perhaps, but the criminal record is not an unbiased measure of criminal activity. So if you have a Black person and a white person with the same criminal record, if you had to take a guess, who's committed more crimes? Probably the white person, because for a Black person and white person that commit the same crimes, the Black person is more likely to be arrested, more likely to be convicted, more likely to be incarcerated, not only because of kind of classic racial bias in our system, but also implicit bias, a variety of structural biases. If you live in a minority neighborhood, you're more likely to be, you just have more interface with police. It's just more heavily policed. If you're arrested, you're less likely to be able to afford your bail. If you're detained pre-trial, you're more likely to plead guilty, because maybe the prosecutor offers you a plea deal that allows you to go home. It might have huge fines and 5 years of probation, but you take that plea so you can go home. You're less likely to be able to afford a private attorney, so on and so forth. So there are all these ways that structural disadvantage means that the criminal record is not a good measure of similarly situated individuals. There are some kind of more complicated econometric techniques of trying to get at the idea of whether the judges have a similar risk threshold for Black and white defendants. I'm not sure if it's worth getting into like the weeds about exactly how these scholars have tried to uncover this, but the gist of the story is that there is very clear and robust evidence that Black people are more likely to be incarcerated than white people with a similar risk level. And I'm happy to follow up offline if you want to get into the weeds a little bit more about how the authors are looking at this.
I also wanted to point out on that I think it's worth, like, the way I frame this idea in my head is that I think some of these inferences are a lot easier to make in aggregate than they are like on like once you start picking out concrete terms and concrete variables and dimensions, not ones that are like super intuitive to most.
Thank you. Commissioner, do you have a follow-up question? Otherwise, I can turn to Dave Kladney because he wanted to ask something.
I have one more. Justice Herndon, earlier we heard that part of the realities of the criminal justice system is that a very short amount of time is being spent on bail determinations in the real world, in courtrooms, and the volume of criminal cases, the amount of time that both prosecutors and defense counsel have to attend to their quite heavy dockets. The court's docket itself means that there is not a lot of time being spent on even what we now understand to be the flawed system that is in place. There's sort of a limited amount of time that people can use, which I take it the testimony earlier was suggesting undermines the validity of the approach. And I just wanted to know, as somebody who has spent a fair amount of time in courtrooms, what is your assessment of that structural piece of the process?
So, look, I think it's incumbent upon all of us to spend as much time as we need to getting prepared for things to make intelligent decisions. Things in Clark County, for instance, we've always had one of the highest caseloads per judge in the country, just because Las Vegas, Clark County has been a very, very growing population for the last couple of decades without the resultant increase in the number of judges, the number of public defenders, the number of prosecutors, right? Again, politics are not given as much money to fund those things, even though we have massive amounts of people moving in, which means caseloads go up. So what happens in court often does happen, Commissioner, in minutes. But hopefully You as a judge have prepared everything before that. The attorneys have prepared everything before that. In district court at the trial court level, it's vastly different again than it is down at the lower court level, where oftentimes attorneys are just meeting their clients for the first time, don't have a lot of information that they can rely on to present matters to the judge. By the time we get up to the trial court level, they've usually got a lot more information about their clients. We know more about what the allegations of the crime are, and you can have a more intelligent and robust discussion about bail issues, hopefully. But you're right, at the lower court level, particularly, whether it's city courts or justice courts that are the probable cause courts for the felony matters, at least in Nevada, things are happening very, very quickly with very little information. But, you know, it's kind of a catch-22, right? You want to get people into court very quickly so they're not detained without a judge being able to assess their bail status or their release status, but there's not a lot of information available to people to kind of intelligently have that discussion.
Can I add on there? So I just want to say that, like, I just want to acknowledge how horrible that is. Like, as human beings, like, this is people's freedom. This is freedom. This is jail we're talking about. Jail with rampant with violence and disease and terrible food and like everything, you know, like heating infrastructure that fails so that you're left in freezing conditions. I mean, like what's going on in Texas in the last week, you know, like no water, toilets overflowing, freezing cold temperatures, like barely sufficient blankets. Like to have decisions, the decision to place somebody like that being, you know, into a condition like that, being made in like 30 seconds to a minute, that is just unconscionable. As a human being, that's just unconscionable. Now, I understand that there are pressures on the system, but our choice is not simply this method or make them wait even longer to get to the bail hearing to, you know, like clog up the, I mean, we have other, you know, we have other choices. For one, we could simply prosecute, you know, way fewer crimes. We could make way fewer arrests. We could put a lot more money into this system so that we're not engaging in such horrific human rights abuses as we currently are in our system. We should, put systems in place that slow it down even more, that make people not inclined to have to, accept a plea bargain because they honestly feel like they have no choice, because they have no counsel that has time to really approach their case, because the sentencing penalty of taking it to trial is too extraordinary. Like, we are so deep into the realm of, like, if you read about this, you would be like, that is a dystopian science fiction novel. Like, that's what our criminal justice system is. We need to move so far to get it back into a place of even like basic human reasonableness. Okay. That we've gotten used to it. We've gotten immune to it, but it's not right.
And I am delighted that there are folk like the folk on this panel who made the time, who found the time, because you have the same number of minutes a day as everyone else, but you found the time to discuss and to search for better solutions. Our country deserves better. Our country.
That's right.
I'm going to let David ask his question because he's been holding patiently. Commissioner Kladney.
One of the few times people have called me patient. Ms. May, you've been very quiet during this panel, and so I have structured this question for you. Which system, specifically relating to the Houston consent decree, do you think might be a model for bail? Do you have thoughts on that?
In terms of systems, so a lot of our work has been around, in terms of just modeling bail, has been around prosecutors' offices specifically, and getting them to introduce policies that don't increase, that to not take money bail. But in Houston, in Harris County, Texas, the courts have been, the county has been, is required to release anyone within 24 hours of being charged, whether they, no matter what they've been charged with. And I think in terms of there was a question about race earlier that I wanted to answer when it comes to this, but the reports, so I think that is a very good model. And I think what the studies have shown is that when we release people, there is no increased risk, as Dr. Stevenson has said, there is no increased risk of people returning to prison and jails. And then we've also seen that in that system, particularly, the studies have shown that the racial disparities amongst people who are released pre-trial have actually declined because of that system, because of the system that releases people automatically. And I can provide more in an amendment to my written testimony. I can provide a couple of more models around the country that we're looking at.
We would appreciate that. Thank you very much.
Commissioner Yaki, do you have any last questions?
No, I mean, I was just going to make a comment to this panel, which is what I'm hearing from a number of you is that bail reform as an issue is an outgrowth of the criminal justice reform as a whole, and that it's hard to separate one from the other because it's whack-a-mole in terms of policy and trying to capture all the different parts of this, whether it's the intake, whether it's the outtake, whether it's the charging decision, whether it's the behavior of the police at the scene and their discretion. All these things come into effect. So I commend you for all the great work that you're doing on a very, very difficult topic. And thank you so much.
Well, this brings us to the end of our briefing. I'd like to take this opportunity to thank all of the panelists. It's been tremendously informative, and on behalf of the entire commission, I wish to thank all the panelists for sharing their time and in particular their expertise with us. I also want to personally thank the commission staff for the efforts they've made in the last few months to pull this virtual briefing together. I want to thank the staff in advance for the work that they're going to do to distill the information presented in this briefing and to incorporate it in the report. I'm very grateful for all of their hard work. The recording for this briefing shall remain open for the next 30 days. So if panelists or members of the public would like to submit materials, they can mail them to the U.S. Commission on Civil Rights. Care of the Office of the General Counsel, 1331 Pennsylvania Avenue, Northwest, Suite 1150, Washington, D.C. 20425. Or be more up to date and email us. The email, after I gave you that long address, I said, just ignore it. Email us at bailreform@usccr.gov. That's bailreform@usccr.gov. Pardon my Texas accent. Thank you all, and the briefing has ended. Thank you.
Thank you, Madam Chair.
Hope to see you again.